Yes. So good evening to one and all. Thank you for joining the NAJAR's webinar on the Bihar SIR judgment, that is ADR versus ECI, that was delivered earlier this week. And we have very distinguished panelists with us today to discuss the implications, the far-reaching implications of this judgment on the principle of a universal adult franchise, perhaps undoing decades of work towards building a more robust democracy. Uh, the speakers don't need much introduction, but just quickly to give a brief introduction about each of them. Prashant Bhushan ji is a public interest lawyer who has been at the forefront of many civil liberties issues for decades. And Shadan Farasat ji is a senior counsel who has also been interested in the constitutional law question as well as public interest work. And both of them have been at the forefront of this particular litigation. They have argued this matter extensively before the Supreme Court. Then we have Darshana Mitra, who's an assistant professor at the National Law School of India, where she runs a clinic on the citizenship and immigration law. And she works on cases of citizenship deprivation in Assam and elsewhere. She's also been working to provide legal support for appeals against SIR exclusion in West Bengal. Sarfaraz is the General Secretary of the People's Union for Civil Liberties in Bihar, and he has also been actively involved in providing assistance to people who in Bihar whose names have been excluded from the lists, the draft list as well as the final lists. And so Rahul Shastri is a researcher from the Bharat Jodo Abhiyan, who has also been actively involved in providing support to individuals excluded in the Bihar SIR process. So welcome and thank you to all our speakers for agreeing to shed light from various aspects and various perspectives on this process. I think lawyers and activists together, when they come together, a lot of successful litigation has to happen. But here, of course, there's a lot to be discussed on why this particular judgment, how it came about, and like the whole politics behind producing this particular verdict as well. So it will be important to discuss this verdict in detail from different perspectives, both from the perspective of the lawyers who argued on this matter, as well as the ground activists who were involved in the on this question and the implications of this exercise on the ground. So welcome, and we will start with Prashant Bhushan ji. My question to you, Prashant Bhushan ji, is as we know, the Supreme Court has held that the Election Commission has essentially unfettered discretion to conduct this exercise as it deems fit, right? And it goes into a detailed legal analysis to come to that conclusion. What is your take on the reasoning of the court? If you could debunk what was argued in court and what the court has recorded in its summary, and the reasoning it has applied. Yes, thank you. We can.
Thank you, Mridula. So the judgment on the Bihar SIR case came almost 6 months after the Bihar elections had been held, more than 6 months after the Bihar elections had been held, and also after the West Bengal elections had been held. And therefore, no one expected the Supreme Court to hold that the SIR was unconstitutional. But we did expect the Supreme Court to put some brakes on the powers of the Election Commission in the manner in which they conduct the SIR, in line with the acts, with the law, in line with their own rules, in line with their own manual, and in line with the Supreme Court's judgment of Lal Babu Hussain, which decided how the Election Commission could exclude somebody from the voters list on the ground that he is not a citizen. So the judgment unfortunately disappoints all of us. Of course, there was a very important and, in my view, a very strong ground for holding this kind of SIR exercise to be illegal. Because after independence, when the first voters list was drawn up in 1950-51, after that, there has never been any attempt to draw a fresh voters list in the manner in which this SIR seeks to do until now. There have been earlier SIRs, special intensive revisions. The last one was in 2003. And in those SIRs, there was door-to-door enumeration on the basis of the previous voters list. There wasn't this kind of fresh voters list that you have to fill up an enumeration form. And if you don't fill up that enumeration form, which is also a long, complicated form, then your name will automatically be out of the voters list. And thereafter, you have to provide one of the specified documents, which very few poor people have. Even a single one of those documents, few poor people have. Of course, the Supreme Court later added the Aadhaar card to that list. And Aadhaar, most people do have. The majority of the people do have the Aadhaar card. But they left out other critical documents like ration card, bank documents, electricity connection, water connection, and so on, from the documents which were specified. So what the Supreme Court has essentially held is that the Article 324 of the Constitution, which vests the Election Commission with the power to do whatever is necessary to conduct free and fair elections, vests the Election Commission with virtually plenary powers. At one point, they do say that these plenary powers cannot be exercised in violation of specific statutory provisions. But in other places, they also say that, well, specific statutory provisions will have to be reconciled somehow with the Election Commission's decisions to conduct the SIR in the manner in which they want to conduct it. So that is also not very clear as to whether specific, because we did point out some statutory restrictions, some legal restrictions about the manner in which they can conduct the SIR, but even that has not been fully accepted. Also, we pointed out various rules as well as from the Election Commission's manual about transparency in this whole exercise, which also the Supreme Court has not even referred to while delivering this judgment. We also pointed out that their own manual and instructions require them to use a deduplication software to detect demographically similar and photographically similar entries, which they did not use. And the Supreme Court also allows them to do whatever they want, however they want, etc. And one very sort of unfortunate thing that the court has done is that while allowing the Election Commission to remove people's name from the voters list on the ground of citizenship, on the basis of their own subjective satisfaction, without following any rules, any guidelines, etc., they further say that though the names which are removed from the voters list on the basis of citizenship will not ipso facto be deprived of their citizenship, which means of their other entitlements as citizens like rations, etc., but the Election Commission would refer those names to the competent authority, which means the Home Ministry, and thereafter the Home Ministry will decide their citizenship, etc. And all this has been done without the court even asking the Election Commission as to how many people were deprived of their voters' right on the ground of citizenship. We kept asking the Supreme Court to ask them to disclose which people, how many people have been deprived of their voters' rights on the ground of citizenship, but the Election Commission refused to answer, and the Supreme Court also declined to even want to know this figure, and they have just given a carte blanche to the Election Commission to do this. So, all in all, it's a very, very frightening judgment, and it has very frightening consequences for the future, because it virtually vests the Election Commission with almost unlimited powers to conduct determine the voters list as it pleases, irrespective of whatever they may have said in their own rules, whatever is provided in the rules, whatever they may have said in their own manual, and irrespective of what has been done in the past, etc. So it's a very, very dangerous thing, and this danger is especially more in the context of a totally partisan election commission that we are seeing. In fact, the Supreme Court Constitution Bench of the Supreme Court in ADR's own case had said that the election commission cannot be appointed by the government alone, and therefore they must be appointed by a committee consisting of the Prime Minister, Leader of Opposition, and the Chief Justice. Unfortunately, the government overturned that by bringing in a law which said that no, the Chief Justice need not be there, and they substituted the Chief Justice with another minister, as a result of which the government now appoints the Election Commission, because Leader of Opposition can only issue a dissent note, which they have been doing, and the government has been appointing whosoever they please. And from the past actions of the Election Commission, recent actions especially, it has become increasingly clear to everybody that the Election Commission has become a stooge of the ruling party, and therefore vesting them with virtually unlimited powers without even restricting them on the basis of their own rules, on the basis of their own manual, etc., in my view, spells great danger for our democracy. You see, in Lal Babu Hussain, which was the Supreme Court judgment of a larger bench of 3 judges of 1995, in the context of another such deletion of voters' names on the ground of citizenship, the Supreme Court held that, look, if a person's name is in the previous voters list, that will be prima facie evidence that he is a citizen. If the Election Commission wants to doubt the citizenship of a person, they have to give him a show cause notice with reasons as to why they doubt his claim for being a citizen. After that, they have to give that person an opportunity to tender whatever evidence, give him a personal hearing with an opportunity to tender whatever evidence he wants, including documentary and oral evidence. And after that, if they don't accept his explanation, they have to pass a reasoned order for excluding them from the roll. Now, none of this was done in the present exercise. There was no show cause notice. There was no personal hearing. There was no opportunity to adduce any kind of evidence that the person wished to do, which included his ration card, his electricity connection, water connection, various other bank documents, and oral evidence, including affidavits of that person, as well as suppose somebody doesn't have any documents, but he gives an affidavit saying that, look, I was born here, I have been living here, my parents were so and so, they were living here, etc. That is also evidence which has to be considered by the Election Commission. Election Commission cannot seek to exclude this kind of evidence and say that we will only consider this evidence. Unfortunately, the Supreme Court has not even accepted this binding judgment of Lal Babu Hussain and has sought to distinguish it by saying that no, that Lal Babu Hussain came in the context of several SIRs in the past, and this is now being done after more than 20 years of an SIR. That's an absolutely bogus distinction that they have sought to make. Very unfortunate for the Supreme Court to have done this. And it has left people virtually at the mercy of the government. It will spell enormous danger and trouble for particularly Muslims in this country, which this government has been trying to exclude from citizenship for years now. First, they said that we will declare a Hindu Rashtra and we will render these Muslims second-class citizens. Then they realized that they can't do that because that is basic structure of the constitution. Then they said, all right, we will do it through a National Register of Citizens, NRC. They did that in Assam, but unfortunately for them, because the Supreme Court monitored that citizenship exercise, therefore 70% of the people who were excluded from that 19 or 20 lakh people who were excluded from citizenship from the register were Hindus, and only 30% were Muslims, which is roughly the composition of the Hindu-Muslim population of Assam. So it's very, very, very unfortunate that the Supreme Court has virtually allowed the Election Commission, which is a stooge of the BJP, to now do the same thing through a non-transparent SIR process, and thereafter virtually exclude them from citizenship by referring them to a home ministry, which we know is totally biased. And thereafter they say that you can challenge their decision in a court, and we know how long the court takes. And in the West Bengal case, we saw that they used a totally bogus thing called logical discrepancies to seek to exclude the names of 60 lakh people. Finally, they excluded 27 lakh people from the voters list in West Bengal. And out of these 27 lakh people, 2/3 were Muslims and 1/3 were non-Muslims. This was clearly a targeted exclusion, and they did not even show the software. People were asking, what is the software that you have used for identifying people with logical discrepancies? They are saying that if your father's name is spelled one way in one document, another way in another document, that's a logical discrepancy. Now, if this was the basis, then I can guarantee that more than 2 crore people could have been identified as having logical discrepancies on this basis. But they identified 60 lakh people and they deliberately targeted Muslims. And all this, of course, they have not dealt with the issue of logical discrepancy in the context of the Bihar SIR, because Bihar SIR, they did not use logical discrepancies. This was suddenly discovered by the Election Commission just prior to the West Bengal election. So, and we pointed out several rules of transparency. For example, the rule said that whenever a person gives a Section 6 application for including his name in the electoral roll, it has to be put out on the Election Commission's website for everybody to see. Whenever somebody gives a Form 7 application for excluding somebody's name, that also has to be put out on the website for everybody to see. But the Election Commission was not doing that. We kept telling the Supreme Court that, look, at least make them follow their own rules, their own manual. But unfortunately, the Supreme Court has not done any of that and has virtually given them a blank check for doing the SIR in any way that they want. As I said, this spells great danger for our democracy, and it's indeed, in my view, a very dark day for our judiciary, especially the Supreme Court, for having allowed or for having given this kind of blank check to a totally partisan election commission. So I'll stop here. Thank you.
Thank you, Prashant ji. That also was like a good overall elaboration of the judgment itself. That was very useful. My next question is for Shadan, sir. And I want to ask about the procedure that has been validated, right? The procedural powers that the Supreme Court is upholding of the ECI is very broad, and it also basically finds nothing wrong with this burden of proof being heavily on the citizen. And it while it also validates the procedure adopted in the Bihar SIR, it doesn't go into the question of due process much. And I noticed that these arguments have been made by the petitioners, but it has not been engaged with by the Supreme Court, which means that the practices that Prashantji just described, or in that is happening in West Bengal, for instance, has been basically validated, which also means that blatantly, like, oh, there's so much there's so much non-transparency in those practices that they've adopted, like not issuing notice, changing rules arbitrarily. All of this now becomes validated. Isn't that so? So where does due process go then, is my question to you. And also, how do we, like, what can we, how else do we formulate an argument on due process in the other SIR petitions?
Um, Thank you, Mridula. So you're right about the due process question, but before I come to that, I'll just sort of frame a little bit the case itself. So, like Mr. Bhushan said, I think the way the bench had proceeded, I don't think any of us expected that constitutionality will be found to be not there. Because I think in the oral comments during the hearings, the bench was very clear that, we are letting the process go ahead, not on one occasion, but on multiple occasions, both in the Bihar case and as also in the West Bengal and even some petitions came from Tamil Nadu, etc. as well. So I don't think any of us sort of anticipated or expected that. But I think the real disappointing bit of the judgment is what we did expect is to rein in the process, right? And I think what it has done, instead of reining in the process, it has totally validated the process. And while validating the process, a process which is so defective on the face of it, I mean, it requires elementary common sense to see the problems of it. You have one process in Bihar. You have a completely different process insofar as a new category is brought in, which is a category effectively to exclude. And quite evidently, targeted exclusions have happened. So if given that experience, the Supreme Court then says that, yes, you, the Election Commission, can do whatever you want, and you are not constrained either by the act or by the rule. And Article 324, which gives you a broad power, is all there is. And you can really do whatever it is, and we find everything very fair and reasonable. I think I personally found that a little shocking for a constitutional court to be saying that. Because I could have understood if it was a theoretical question where these issues had not arisen. But I think the court had actually engaged with so many of these issues in multiple IAS petitions, etc. They had been brought in, right? So after seeing that, and even today, you had 27 lakh voters who couldn't vote, and most of the appeals, my understanding is 80% of the appeals are being allowed, or about in that number. So most of them will actually be back on the rolls, but they were specifically excluded from a particular election. So having seen all of that, having really presided over all of that, then to give a procedural carte blanche to the Election Commission is, I think, just looking the other way insofar as the Supreme Court is concerned. I mean, I was really surprised by that bit, because I thought that they will definitely constrain, and a lot of us had argued different formulations. I had specifically argued that, of course, even if you can do this intensive revision, earlier what had happened in all earlier cases, including 2002-3, was intensive revisions. This is a new category called special intensive revision. It's the first time it's happening. A special intensive hadn't happened. A lot of times people confuse intensive revision of earlier times with a special intensive. So this is the first time. And the reason is that those were carried out in terms of the existing rules, etc. They have laid down the procedure, and procedure changes every day. They were issuing administrative circulars, they were issuing executive notifications, which changed the procedure every day. There was WhatsApp messages which were going to instructions which were contrary to circulars. Now, that's the manner in which this exercise of enfranchisement, rather than disenfranchisement, has been carried out. With all of that to be clearly seen, and none of this was not, the Supreme Court was not aware of. It was pointed out by different parties at different stages, because we went in the last June when it was before a vacation bench when the matter was first heard, as soon as the notification came out. And thereafter, now we are, as you can see, in June, right? Effectively, we are end May. So judgment has come 1 week back, last Monday. So, yes. So effectively, the matter has gone on for 1 year, right? And the court had been exposed to all the follies of this SIR process. Then to do it, I mean, it's really, it's very disappointing. I think the court in this specific instance has failed to act as a constitutional court. Because normally what happens is, in a lot of cases where the court is a little reluctant to strike down something as unconstitutional, and there could be some, good reasons for that, you definitely balance the process so as to ensure prevention of its abuse. What we are seeing in this case is abuse after abuse has been brought to the court's notice, and the court says all is fine. This is the procedure which is all okay. Now that really is, as lawyers who sort of argue before court with a belief system, with as that okay, at the end of the day there will be, you may have disagreements on the degrees of the problem, but at least there is some agreement on that there is a problem. I think if even that is lacking from the court side, then it really, makes us question also in why we are sort of going to the court every time and arguing these things, right? Because if the court is going to be seeing everything and then unsee it, then, what is the point? But I would say that this two-judge bench also, I agree with Mr. Bhushan that insofar as Lal Babu Hussain was a binding precedent, they have not adequately differentiated it. The ground for differentiation is rather flimsy, if I can use that word. And it did give a right. We expected two things. I personally, speaking for myself, I thought that what they could say potentially is that they could say that, listen, although it's constitutional, but you cannot act beyond the registration of electoral rule 1960. You have to carry out that process within the scheme of that. You cannot keep on adding, deleting, having a mechanism completely outside. And that was a very reasonable view to take. There was enough textually in the rules and the act to come to that conclusion. In fact, that, according to me, was the predominant textual indication from the act and the rules. But the court did not touch that at all. And second, what they could have done was that existing voters should not be knocked out without a proper hearing. That was Lal Babu Hussain principle, effectively. That they could have given some weight and brought that in as well, going forward. The fact that they failed to do either of those two things and said this procedure, which is obviously unreasonable and erratic, to call it reasonable and non-arbitrary, I think the court is diminishing itself, let me put it that way, by actually authorizing something like this. It's actually not the election commission itself which is losing out. But I think the court itself is also getting diminished in the process by approving something as bad as this. So I would leave it at that.
Just follow up, Shadan, sir. The court also notices that there are already or it interprets safeguards into the process which don't exist. For example, it says there is a notice stage and hearing stage, but there isn't proper notice because only one set of, I think, the people in the draft list will get, and then the people in the ASDD list or the addition ASDD list where the dead and absent voters list is there. They don't get a notice at all. They are just excluded, and the burden is on them to go to the find out that why their name is missing, and what happens thereafter is also not very clear, right? So were these things brought to the court's notice? Because we don't see the court engage with any ground level facts at all. We don't see them because these are
no. So a lot of it, I think, this judgment. Yes, sorry. No, so I think this judgment, one of the fundamental problems is that a lot of arguments which were made have not even been noted, right? Yeah. And some arguments. So what has happened is a whole range of arguments were made. Some have been noted, some have not been noted. Even the ones which have been noted, a lot of them have not been dealt with, right? So it's just noted, but actually when you come to the court's reasoning, the court has just taken this thing, and those were, I can understand, that the issues on the side or on the margins, court need not deal with it necessarily just because the argument has been raised. We see that every day in judgments. But these are all matters which go to the core questions, and they are very credible arguments. They are not some fanciful arguments being made by lawyers. So a lot of factual thing on the ground was laid before the court. I clearly remember Mr. Yogendra Yadav also in person argued. And for instance, this whole mechanism of how it flips the burden from the election commission to the voter He showed the data where countries which put it on the voter, the registration rates are much lower. India has historically had that, and that's why we have a higher registration rate. He showed all of that, and he argued quite beautifully. So different kinds of arguments, a holistic, actual, practical argument, legal, constitutional arguments, all of that were placed. So I don't think anybody should be under the apprehension that in this judgment, anything has happened for a lack of putting it before the court. I don't think that's the case at all, right? So everything was put forth. The court really, in this case, seems to have cherry-picked what it wanted and actually not even picked anything. It just has finally given its own reasoning on the question. So I think it's really not dealt with a lot, which it was, in my view, should have dealt with for the judgment to have some credibility.
Thank you, Shadan, sir. I think that also takes me to the next question for Darshana, where this idea of this safeguards, one of the safeguards that the court reads into this process is that there are multiple avenues for a person who's been excluded to go to. And since you're dealing with the Bengal SIR process where excluded voters, basically appealing on behalf of the excluded voters, what are these multiple avenues? Is that really existing? And what happens there at the appellate stage once once your name doesn't find itself in the once you don't find yourself on the final list, what happens then? And is it really true that there is an effective appellate mechanism in this exercise? Yeah.
Well, I'll just quickly speak to what the Bengal appellate mechanism, which is that it doesn't seem to be. One is, I think we need to think of this as a question of scale, right? When you exclude 27 lakh people, and it's not 27 lakh people who have been excluded after logical discrepancies, and these are the people who have been given the right to approach the sort of ad hoc constituted appellate tribunals. The people who have been excluded at the mapping stage, for example, are not folks who have the right to approach the appellate tribunal, and that's a much larger number. So that's one thing to remember. And what they've been told essentially is that you can just fill up a Form 6 and enroll as a new voter. But for those who have been excluded at the second stage in Bengal because of the logical discrepancy reason, that's 27 lakh people, and then there's some people against whose inclusion appeals or objections have been filed. I think that brings up the number somewhere to 30 lakhs. Now, I think first and foremost, we should see this as a question of scale. That when you exclude 27 lakh people, right, and we can just look at the pendency figures of just regular civil and criminal courts in India, in any district court in India, or any state in India, right? 27 lakh cases entering the system at one go is never going to work out as a realistic appellate process. It just isn't. So even the most well-designed appellate process is going to buckle under the weight of so many cases, right? And why do I say it'll buckle under the weight of so many cases? Because really, judicial processes, and anyone who's done any work on judicial pendency will know this, right? Judicial processes are run by flesh and blood human beings at the end of the day. Judges will not sit 7 days a week, understandably. They will sit 5 days a week. You push it to 6 days a week. They sit for 8 hours, 6 hours, 5. Like, that's the number of hours they will sit for. It is humanly impossible to dispose of 27 lakh appeals. Obviously, it was always going to be humanly impossible to do it before the Bengal elections. I think no one was under the misconception that any of this was going to happen before the elections started and ended. But it is also, I would argue, it is humanly impossible to do it in an individual's lifetime, right? If you have because that's just that is not the lesson we've had from Assam, for example. In Assam, where you had a similar intensive revision taking place, which in 1997, which led to the devoter mark exercise, right? And devoter regime, 3,13,043 persons were marked as devoters in Assam. Their cases were referred to the foreigners tribunals. Then those cases are still pending. You haven't had 100% disposal of 3,13,043 cases. So 27 lakh cases is I don't think, and we're talking about nearly 3 decades in Assam. So if one does the math on just these lines, I think it's quite evident. I'm sorry, someone's speaking. Someone's singing. If they can switch it, that would be great.
Sorry, I'm just going to Mr. Mangur. What is it? 1 second, just a minute. I
No,
can't.
it's very lovely, but it's not. It's not the.
I can't. Yeah, sorry. I am just going to mute this person.
It's okay.
I can't seem to be able to mute them. Sorry.
But
Yeah,
I
I've
think it
muted
sounds
them.
gone right now.
Yeah, I've muted them.
Okay. No, that was a lovely interlude. Yeah, that was a very lovely interlude. We can get back to this. So I
Yes,
think
sorry
there's a
about that.
question of scale here that we're missing.
Hmm.
That's okay. That's okay. And that's one thing, right? That I want to point out. I also want to just also say that the one person in the appellate tribunal, Justice B. Sivagnanam, who was a retired justice of the Calcutta High Court. He was on the appellate tribunals. He was disposing of cases as fast as possible, and the majority of the appeals that were being filed before him were being allowed. He resigned from the appellate tribunal very soon, right? And I don't. I mean, I'm just putting this sort of factoid out there, that we make of it what we will, but I don't think it is new. It is at scale. It is possible for 27 lakh appeals to be disposed of in an individual's lifetime, not with 19 tribunals. And I think the number of tribunals that you would need in order to dispose of 27 lakh appeals would necessarily mean that you could not have retired high court chief justices or high court judges sitting on them, right? Because what if you have to scale up this process, you will have a trade-off in terms of quality. And when you have the trade-off in terms of quality, then you bring in judicial officers, and then at some point of time, again, you take the path that we've taken in Assam, which is that you keep reducing the qualification of persons heading these tribunals. So it goes from retired judicial officer to advocate of 10 years experience, advocate of 7 years experience. That's exactly what's happened with foreigners tribunals in Assam. I'm using foreigners tribunals not because they're not the same thing as the appellate tribunals in West Bengal. I just want to make sure that that point is clear. But I'm using foreigners tribunals as an example of what happens when you exclude a lot of people from an electoral roll en masse, and then you set up a process and you show that process as this is how all of these people will get a fair hearing. The fact is, we live in flesh and blood, we live in time, and it is absolutely impossible, as we see through in Assam, to have both quality adjudication by a retired judicial officer and to have it done within the time necessary for it actually to mean anything effective for the individual who's been excluded. So I'm not even going into the process of hearing, largely because it is not something that I am privy to. It is not something that, unless you filed an appeal, anyone is privy to. The SOP for the appellate tribunals in West Bengal has not been made public yet. We don't know what that SOP looks like. We don't know what that process is. That itself is a due process violation. The fact that I'm walking into a tribunal not knowing what is the process that I will be subjected to. But I will not speak to that process because I don't know what that process is, as is most people don't know what that process is. But I can just tell you the numbers and say that this can't work. I don't think this can actually work.
Thank you, Darshana. Just to follow up on that, because we are coming to this citizenship aspect through this, right? So, okay, you find yourself out of these lists and you go to these appeals, and your appeals, you're unsuccessful there, and the court very categorical. I don't know if it was even argued, but the court by itself categorically says, then if you're out, then your citizenship will have to be established, even though the ECI cannot go into cannot conclusively determine citizenship, only to the limited extent of the process it can determine your citizenship to that extent. Thereafter, you have to go to a competent authority that is established under the Citizenship Act of 1955, what the ruling says. Now, what is this competent authority? Is it is it sort of referring to, for example, the Foreigners Tribunal in Assam? Is it that? So, what is your reading of this particular direction of the Supreme Court in this case?
Okay, thank you. Thanks, Mudra, for that question. So just I want to clarify that, and I think this also speaks to another question that you had asked me to think about, which is that just because you're out of the SIR, legally there shouldn't be a presumption that you are not a citizen, right? A negative presumption does not operate in this case. One, because primarily because you can be excluded from an electoral list for n number of reasons. Not being a citizen is only one of them, right? You can also actually be excluded from an electoral roll if you're not a resident of the constituency in which you are sought to be enrolled, right? So citizenship is only one ground among all. No one, to my knowledge, yet, maybe it's happening and it's not something that's surfaced yet. No one, to my knowledge, yet has received the notice which says that you've been excluded from the SIR, from the electoral roll because you're a non-citizen, because we suspect that you're a foreigner, right? Now, what this necessarily means that of the people who've been excluded from the SIR, there's going to be a subset that's going to be suspected of being a foreigner. It's not going to be everybody, it's going to be a subset of the larger set, right? So that's something to keep in mind. Now, like you've correctly pointed out, the Supreme Court has said that, and it's made this very interesting distinction. It said that, this is in para 170, I think, 4 of the judgment, where the court says that in our considered view, there's a clear and principal distinction between an adjudication of citizenship on one hand and an administrative satisfaction as to eligibility for enrollment on the other. The former involves a conclusive determination of status under the Citizenship Act. The latter is a limited inquiry undertaken for the purposes of electoral representation. Now, I think this is I think extremely important, because what the court is doing here is remember that one of the questions that is being asked before the court is that, is the ECI competent to decide, conclusively determine citizenship, right? And the court is saying, no, it's actually the ECI. The court is not saying anything about the ECI's competence, but the court is also saying that the ECI is not answering, conclusively determining citizenship. This is not an exercise that the ECI says, no, you're not a citizen, or yes, you're a citizen. However, what the ECI is doing is, it is simply saying, okay, we believe you're a citizen and therefore we include you in the electoral roll, or no, we suspect you're not a citizen, and that's it, right? So it's a yes or a maybe. Yes, you're a citizen and therefore we enroll you. Maybe you're not a citizen and therefore we, don't put you in the electoral roll. It's the maybe which is the problem, right? Because one of the things that I think bears paying very close attention to is that what are the processes that trigger a citizenship determination. Citizenship determination ideally should not happen in the ether, right? Like it should be either linked to a right or linked to a consequence. The right could be the right to vote. The consequence should be that, oh, I have been arrested under the Foreigners Act and now the Immigration and Foreigners Act. I am arrested because I'm suspected of being a foreigner and having illegally entered the country. I have raised a plea that I am a citizen as my defense. And if I fail in my defense, plea, then I will be convicted, and then subsequently I will be incarcerated and then deported, right? So there's a consequence that is attached to this. Now, what the Supreme Court has very cleverly done, I think in that it has also cleverly sidestepped the Lal Babu Hussain question. Because in Lal Babu Hussain, the Supreme Court actually does not conclusively say that the ECI cannot determine citizenship. In fact, Lal Babu Hussein's directions sort of presume that the ECI is determining citizenship. And if the ECI is determining citizenship, these are the limits these are the ways in which the ECI should exercise the power. What the Supreme Court in this case in ADR is that they say that, okay, but the Supreme Court is not. So if the Supreme Court is not conclusively determining citizenship, certainly it is arriving at some sort of subjective satisfaction for the purpose of creating an electoral roll. But if it is not determining it, right, then perhaps the ratio and the directions in Lal Babu Hussain do not extend to it, right? So it's been characterized or reframed as an entirely different process, not as a conclusive determination, but merely as an inquiry. Now, the inquiry happens, right? And the ECI finds that, okay, this person we don't think this person is a citizen of India. The question that arises is, then what? What happens when a question mark has been attached to your forehead and the ECI has moved on with its life? Because once a question mark has been attached to your forehead, the ECI does not care what happens next. Because its job as far as the updation of electoral rolls is done. And now the Supreme Court is also telling us that that job is done. Because once that question mark or once that doubt is cast on you, then the arena shifts to a completely different authority, which is whatever they've called the competent authority under the Citizenship Act. Now to your question, which is, who is this competent authority? Now, the Citizenship Act actually does not contemplate the question of citizenship determination in too many places. There's actually only two places where the question of, as far as I can recollect, the question of citizenship determination comes up. Because primarily the Citizenship Act is a question of who becomes a citizen of India, right? The one place where the question of citizenship determination comes up is where it's what's come up in the ADR judgment, which is Section 9, which is your termination of citizenship. Which is, if you acquire the citizenship of another country, then you lose Indian citizenship. There, the question of whether you have acquired the citizenship of another country, because it is a question that has to be determined factually, is something that that the power to do that is vested in the central government under, I think, Rule 40 of the citizenship rules. The other instance, which the ADR judgment does not go into, is under Section 6A, which is the Assam specific provision, where you can acquire citizenship of India in Assam if you are a person who entered India between that 1st of January 1966 and 24th of March 1971, right? But in order to do so, if you entered India in that period and you can now claim citizenship. And of course, you entered from East Pakistan, you stayed in Assam, all of those things must also apply. You must first have a finding against you or finding in your name by a foreigners tribunal. So foreigners tribunal must first determine that you are indeed a foreigner who entered in this period, right? And then you can claim citizenship, right? And there's a 10-year period for which you can't vote, etc. We're not going to go into that. And the foreigners tribunal is specifically the body under the Citizenship Act that is supposed to ask and that is supposed to answer questions. Like if the question comes up, has Darshana Mitra entered between 66 and 71, the question will be referred to the foreigners tribunal in Assam. However, I think here what we need to do is read the Citizenship Act and the now Immigration and Foreigners Act, earlier the Foreigners Act together, right? And look at what are the bodies, if at all, that exist in India. And right now there aren't, apart from Assam, there are no judicial or quasi-judicial bodies that can on their own take up this question from a reference to following a reference from the central government. It is only in Assam where you have the foreigners tribunal where these bodies can, on a reference from the central government, take up these cases. Foreigners tribunals are formed under now Chapter 6 of the Immigration and Foreigners Order. They used to be under the Foreigners Tribunal Order 1964. Now, Chapter 6 of the Immigration and Foreigners Order, I think, to my mind, it makes it quite clear that the central government or the state government or the UT administration or the district collector, district magistrate may, by order, refer the question as to whether a person is or is not a foreigner within the meaning of the Act to a foreigners tribunal constituted for the purpose by the central government for its opinion. So, if the central government is the body, or if the power to determine citizenship is vested in the central government, and which we know it is vested in the central government, it is that power can be exercised through a reference by the central government to the foreigners tribunal. Okay, and therefore the foreigners tribunal can then step up and answer the question of whether or not this person is a foreigner. And what the foreigners tribunal offers is only an opinion. Now, I'll just end with saying this, that FTs are not, I keep saying this, right? FTs are not there anywhere else in the country. But there is nothing in the text of the law that prevents FTs from being set up elsewhere in the country. Nothing. There is nothing preventing FTs. FTs are not legally tied to the state of Assam. One of the three kinds of questions that they can answer is a question with respect to Section 6A, but the other questions are not tied to Assam. So if I had to think of who is the statutory body or who is the competent authority, I would say it is the FT. Does the FT exist anywhere else in the country today apart from Assam? No, it doesn't. Is there anything stopping the central government from setting up FTs anywhere else in the country? No, it doesn't. And the last thing that I just want to say on this point, and I know I've taken up a lot of time, so I'll stop here quickly, is that um, something that we should be a little wary of, that Lal Babu Sen says that an opportunity of hearing should be given. And obviously we all want due process to exist, and whatever audio altrum apart from all of that to happen. The thing is, anyone who's worked in Assam and who's familiar with FTs, we know that you do have a right of hearing, right? There is some perhaps lip service to the question of due process that happens there, but frankly, these are not adjudicatory bodies which should be deciding these questions at all, right? Because these are not members. FT members are not persons who are given training. They're free to devise their own procedure, which is a bit shocking given how important the importance of the rights that they're determining, right? And I mean, without going into that in too much detail, because I think it's well documented elsewhere, FTs have not have there's multiple instances of how FTs have gone out of the way to declare people to be foreigners. So yes, if you instituted FTs, you would have a pattern of due process. Whether that is what we want, I think from the experience in Assam, the answer should clearly be like, no, absolutely not. We don't want FTs.
Thank you, Darshana. That was very interesting and detailed. But again, like coming back to the Bihar experience, Sarfaraz ji, aapko, I have just one very important question and another follow-up to that. One is that if you see the agar like wo judgment pade to they are saying that in Bihar appeals koi nahi gaye hain.
Yes.
राइट वो कितना लाइक एटलीस्ट अभी जो दर्शना बता रही थी बंगाल में अपील्स गए हैं उसके बाद क्या हुआ किसी को पता नहीं लेकिन वो गए हैं कुछ है वहां पे लेकिन वो अपेलेट प्रोसेस क्या है वो सब पता नहीं लेकिन सुप्रीम कोर्ट कह रहे हैं बिकॉज सो परफेक्टली किया हुआ है इट डजेंट लुक लाइक ऑब्जेक्शन ज्यादा है और वो 3 लाख जो नाम डिलीट हुआ था उसके बारे में कोई अपील ही नहीं है तो आप ये बताओ कि ये सच है या नहीं और क्यों अगर सच है कि अपील नहीं गए क्यों नहीं गए
I think, am I audible?
yes yes yes
It's clear? Okay. In Bihar, I think it was an experiment by ECI or by the government. How can we execute this process of SIR? And it was done very rapidly, swiftly, hurriedly, so that nobody could understand what is going to happen and what is being done, what is going to happen, or what they are doing in Bihar under the garb of SIR. In the first 10 days, most of the people in Bihar were afraid to understand what the SIR is. They did not, even they could not spell the SIR, what it is. So it was and all the political parties were busy in the election campaign. They were in election mood. So it was very difficult for the stakeholders in Bihar to comprehend it, what is the SIR and how to fight against it. But in the on the flip side, there was a rally of vote chori and etc. Vote Jodo Abhiyan by Congress and other India Alliance parties. That was garnering a lot of people, a lot of supporters were coming there in those rallies. But even then, political parties were not very clear how to fight it. They have the Election Commission have assigned the work of SIR to BLOs, and also they have assigned some political parties also. They can give their volunteers name for this same purpose. So, and the BJP was the first and the largest party who has the largest number of the volunteers for the SIR process. The second largest was RJD. It means the political parties have mm, political parties were agreed to this process, and they have tried to instead of boycotting this process, they tried to make their voters enlisted in the voter list. They tried their best to as many as their voters could be added in the voters list after SIR. So this was the basic proposition. And the civil society also, uh, uh, there were several organizations who were fighting, who were going to election commission like PUCL. Every next day, the PUCL was going and submitting the petitions that these people are not there in the draft roll, etc., etc. And we have also submitted some petitions, some memorandum to Chief Electoral Officer also. But nobody was heeding our voice, though nobody was ready to listen to anybody, listen to any sane voice. Like Mr. Shadan has said that there was no logic in this, and there was no logical hearing also. They were not ready to hear anything. Now comes to the appeal. The section 24, which makes the people to appeal to the district magistrate if their names have been deleted. Do you think those poor people will go to the district magistrate to appeal that their names have been deleted from the voter list? In the ground, when we were going to survey the names of the people whose name were deleted from the list, they even didn't know about that their names were deleted. So how can they go for the appeal? So like the 65 lakh people's name, in those 65 lakh people, the election commission said that 36 lakh people are dead. So if they are not dead, they should be given notice that they are dead. So election commission has then given any kind of notice of their death. So how can they know that they have been marked as dead voters in the voter list? Even if some 27 lakh people or something like that, Mr. Rahul Shastri will make it more clear what are the data, is that they are out of the state. Some 27 lakh people have migrated to other states, as the election commission has said, and their names were deleted. Now, how can you imagine that those 27 lakh people will come here and go to the appellate authority and submit their appeal? Most of them were migrant laborers, migrant workers, who have no idea when and how their names were deleted. All of the males who have left their villages and their wives or mothers were in the village, they have no idea how and when their names were deleted. So this experiment, when they got that they can do this experiment easily. So in the next round, in the SIR 2.0, they made it more harsh, which we saw in the Bengal. There is no logic in the logical discrepancy, but they have proved that we can do this. So, and now the judgment of Supreme Court has given a stamp that yes, you can do it. You have to fear nobody. You need not to worry about the laws, the constitution, or anything. You can do it. The first experiment was of Bihar. So in that case, even if I don't have the correct data that in any district, after the deletion, after the final roll, there must have been some appeals. But since the election came to the doorstep, because it was the model code of conduct was introduced on 6th or 7th October, and the final roll was released on the 30th September. So after the model code of conduct, nobody could do anything. So they had given only 4 or 5 days to do anything. So can you imagine that anybody can do anything? So it was very clever. It was very clever. And I don't think Hitler was even more clever than them, these people. Next question.
I
Or
have
anything
another
to the
follow-up
next
to
slide.
that. Yeah, like if you see Bengal now, they've come out and the implications of being removed from the electoral roll is also that they're not able to. A lot of women have been excluded from accessing welfare benefits in Bengal. So, what other kinds of like, which is of course you've not been able to vote this time. What other implications does this
In
judgment
some
and then,
cases,
yeah.
in some cases in Bihar also, when we were going people to people, door to door, and finding those people whose names have been deleted, we have find some cases, some half a dozen cases in the month of October itself, whose names were deleted from the Vridha pension or Vidhva pension, the widow pension or the old age pension, all because of their names were deleted from the list. Now, the PUCL is again having a door-to-door survey to find all those people, especially women, because it is very difficult for a married woman to prove her citizenship or provide some documents for the legality of her citizenship. So we are now again going to do a survey, or we are doing it currently, to find the women who have lost their government scheme beneficiary schemes also. And surprisingly, in last 10 days, we have found 10 women who have lost their old age pension after this SIR. So it means they have bigger plans. I don't know what will they do, what they have in their minds, but it is scary.
So another, again, last follow-up question. Maybe others will also ask after this. We'll open up the floor for other questions. But one last question is, now people who've been excluded, of course, I mean, one option, that process of appealing to either the DM or the CEC, that will take place, and I'm hoping, are you following up anything, any of those cases from PUCL or anybody else that you know who's following up that process to see what the outcome of that will be, is one question. And on the other hand, who have not even, or who've not even received the notice, like for example, people in the ASDD list, like the absentee, duplicate and dead list, and if they are still there, what are they doing? They couldn't, for example, they might have missed the chance to apply for their enumeration form again and like freshly apply. So what are they there? I'm just looking at people who are stranded with no outcome. They're just there. They couldn't vote in the last cycle, previous election. Now what next with them is the last question I have. Yeah.
Your connection is not, I think your voice is breaking, Mridula.
Is it better now? Did you hear my question? Is it better now?
It is better. I could not hear the last part of your question.
Yeah, basically people who are stranded, they might be in the ASDD list and they might have not been able to now what is their plan for them? How are they, what are their difficulties in applying and applying or freshly getting themselves into the back into the electoral roll? And if PUCL Bihar is sort of following up, then what is their experience of what is happening to the people who've been excluded now? So
First
like
of
what,
all,
yeah.
it is the Bihar or any state like Bengal also. It is mostly rural state. The 89% population of Bihar is rural, and similar condition is in Bengal also. So in rural areas, in remote areas, it is very difficult to ascertain what has happened. Like reporters collecting collective was working in Bihar. They have done extensive reporting in Bihar. And in Simanchal area, Kosi area, where mostly Muslim population is there, concentrated Muslim population concentrated area, like Kishanganj, Katiyar, Purnia, they have found that 80,000 voters were being deleted. But because of the timely reporting of the reporters collective, the government took back their decision of deleting those 80,000 names. So it is the whole process was of defranchising. It was not for adding anybody. It was for deleting names of the people. So the whole process should be strike down by the Supreme Court. And in the first hearing, but I am unable to understand why Supreme Court didn't do that. In the land like India, it is very, very difficult to make people to understand that this is your enumeration form. You have to fill this and you have to submit this form to such and such place and then get a receipt. And then you have to see in the website that your name has come in the draft roll. And then if this is in the draft roll, then you have to do this process. Can you make people to understand this whole process easily to all the rural people living in the Bihar? So you can think that, and you have to do this in 30 days. It is impossible. It is impossible. So everything was done in a haphazard manner. Many people who have filled no enumeration form, their name was there in the roll, and many people who have given their passport for their legality of citizenship, their name was strike off. So how can you say that this was a foolproof process? So now the middle class, whom PUCL or any civil society organization in touch with, they are asking people to fill the Form 6 online because that is more secure. And if you can give any kind of document like other than Aadhaar card, if you have any kind of document other than like your birth certificate, only 13% people in Bihar have birth certificates. So you can understand how can people will get their citizenship in that manner. So I think all those people who are in the ADSD list, they are absent or outside of Bihar, can re-enroll themselves if government allow them to get re-enrolled. But I cannot give any answer about those people who are living in remote areas, especially women folks. How will they get themselves enrolled? There is no idea. This is a big question. This is a big crisis of citizenship in any place of India, not only in Bihar.
Thank you, Sarfaraz. I think we can open it up. I mean, is Rahul here? I mean, I can't see him, but Rahul Shastri, is he? Okay, it doesn't look like he's with us. So maybe we can like open the floor up for questions. Mansi, yes.
Yeah, hi. Thanks, Mridula. So I think my question is to Darshana, and even Sarfaraz, she could answer if you would like to. So as Darshana had rightly said that just because the name has been struck off from the voter list doesn't necessarily mean that there is a doubt on the citizenship, because there can be multiple grounds for removing somebody's name from the voter list. But I think also another fundamental point is that it is not mandatory for any citizen to register as a voter, right? I mean, it's a right that I can exercise if I want to. And if I choose not to register as a voter, not have a voter card made, because for n number of reasons, I do not believe in the electoral process, I don't want to vote. Like, for instance, a lot of people in Kashmir, a lot of my friends have, because of their very fundamental differences, they don't want to participate in the electoral process. They have never got their names enrolled in the voter list, never registered as a voter ID. So while it is true that you have to be a citizen to be on the voter list, the other way around is not true at all. So just because you're not on the voter list I think even by law, cannot raise a presumption of doubt on your citizenship. So does this then effectively make it mandatory in a sense that, I mean, if my citizenship is going to come under doubt if I do not get enrolled as a voter, so is it like really striking at the right of somebody's to, somebody's right to determine whether they want to be registered as a voter or not, and in effect make it mandatory? Otherwise, you can then become a doubtful citizen and be, deprived of all of your other welfare benefits as well. So any thoughts that you have on that? Thanks.
Should I answer, or Mitra, do you want to take more questions as well?
No, I think you can. Do you? I think you can answer, or if anyone else, I don't see any other hands raised. So,
Okay.
But yeah, you can just answer. Yeah.
I'll just quickly answer, and then Sarfaraz can also come in. So, see, you're correct, Mansi, in saying that I'm not legally obligated to vote just because I'm a citizen of India, right? Now, two things here. One is that if you were on the 2003 voters list, right, but you are not, because you did not apply, right? You did not fill in the enumeration form, and therefore you're not in the 2026 SIR, right? Then I would say that is a problem, because then you're still technically deleted from the electoral roll, because you're someone who was eligible to be, but they're not in the electoral roll, and you're someone who's voted earlier and who's been in the electoral roll earlier. One way of seeing this is that if the state does not see you, then there is no problem. If you're not someone who's entered the system ever, then perhaps you can argue that there isn't a problem. But having once entered the system, if you fail to appear regularly, then that creates a problem where you're actually deleted from the voters list, whether it's because you did not apply, or whether it's because you applied but your documents were found to be lacking. So that's one way of looking at it, that if you never applied, then maybe you shouldn't have a problem. However, and I will argue against this only right now, I think one of the lessons we've had from Assam is that your existence on the voter roll, depending on who you are, your caste, class identity, your socioeconomic status, is often the only record of your existence in front of the state, right? So if you have been voting regularly since you were 18 years old, right, then that may be the only way in which you can show that I, Darshana Mitra, have been living in this area for so many years. In fact, and I'm not going to say that that's necessarily what's going to happen in the rest of the country, only because there are differences in the law. But one of the things that we do in pretty much every foreigners tribunal case in Assam is that we produce historical voters list. If that person was eligible to vote in, say, 1966, we will produce voters list from every year subsequently: 1966, 1976, 1986, every decade, sorry, as many voters lists as you possibly can. This is a way of sort of demonstrating that this individual who is in front of you right now is the same individual who was present in the state of Assam in 1966. Now, this is also because of a quirk in the manner in which citizenship law operates in Assam. But this is at least one example where your enrollment in the voters list is your visibility to the state, and therefore the state can't then tomorrow argue that you just crossed over from Bangladesh or wherever, right? Because you can show that no, but I've been voting in this particular constituency since I was eligible to vote. So it's not legally mandatory, but as a way of proving your existence and proving your presence, and therefore proving your citizenship, because citizenship is also just, it's a presumption, right, that I'm more likely than not that I'm a citizen. Being enrolled in the voters list is I think is very important, and it will become increasingly important. We also saw that in West Bengal for the West Bengal elections as well as the Bihar elections, right? So many people travel back to vote this time around in such large numbers. Why is it? Like, I mean, yes, of course, we all love participating in democracy, but it's also the fear that was very real in people's minds was that if I don't vote, they will strike my name off, right? So the act of voting is, I mean, yeah, it is not legally tied to your fact of citizenship, right? But it becomes a piece of evidence to prove your citizenship. And hence being enrolled, if you are someone who is particularly vulnerable to being declared to be a foreigner, right? And of course, there are clear religious lines that are being drawn here, right? But if you're someone who is particularly, you're a Muslim migrant worker, and therefore you're very, very vulnerable to being declared to be a foreigner. This is an important piece of evidence that you are gathering for yourself to show that you belong and that you are a citizen of this country. Yeah, so that would be my answer to your question.
Sarfaraz ji, do you want to go?
I should add only one line in Darshana's statement, that it is up to the government. What they want to do, they can do. Nobody can stop them. And even the last refuge for common citizen like us was the Supreme Court. And we have seen what Supreme Court is doing. Then in that case, they can do what they want to do. Like in Assam, last year, some 50,000 people's house were demolished. Even they have they have their houses under the scheme of Indra Awas Yojana. It means they have got government's money, people's money, taxpayers' money to build their houses. Even their house were raised. So government can do anything they want to do. Even if you have all the cards, all the proof, all those people whose houses were demolished have Aadhaar card. Even some people have passports also. Even then, they were called illegal citizens, and now they are living in the shed, and they are very scared what they are going to, government is going to do with them. So it is all up to the government. This is very, very scary. Thank you.
Thank you. Any other?
Can I ask a quick follow-up question in case there is no other? So, just following up on Darshana's point. So since, for instance, I'm in Delhi, and in Delhi, they're using the 2003 voter list, and I was not eligible to vote at that time. So my name is not going to be there in the 2003 voter list. And now some civil society groups, for instance, in Delhi have been having this conversation on, whether one of our responses to this exercise, could be to boycott. Again, just sort of drawing back to the point that it is not mandatory for me to, under any law, for me to get enrolled as a voter. And so just your thoughts on, so I completely agree with what you said about being visible to the state and etc. But yeah, just sort of your thoughts on the fact that, because you said that if you've never been visible to the state in that sense, and I wasn't there in the 2003 list, but I've been voting since I become eligible to vote. So then what kind of situation does that create then?
I'm not going to advise you to boycott or not boycott elections, only because I think the question of boycotting or not boycotting elections is a larger, one is, like all political strategies, some people are less at risk from certain political strategies, some people are more at risk from certain political strategies. I think to the Bengali Muslim migrant worker, boycotting elections is not an option. But which is not to then say that this isn't a valid strategy of political resistance. Just to say that, because and I think something that Sarfaraz has said, and I just want to, I'll rephrase it for myself the way I would say it is that the law operates in highly selective ways. One of the things that we see, and one of the let me just put it this way, the fact that no one has received grounds yet of being excluded for being a foreigner, right? Could mean could mean anything. It could mean either no one has been suspected so far, and this suspicion is only going to be attached post facto, or it could mean that they've just decided not to act on it, right? But it is, because the Chief Minister of West Bengal has said that people who are eligible to apply under the CAA are not going to be hit with any of the consequences of being excluded from the SIR. What this clearly tells us is this is also a religiously determined exercise. It is determined along caste lines, it is determined along religious lines, which means that people who are at a disadvantage because of the religious and caste identity are at greater risk if they choose to not participate in the very state processes that choose to exclude them. So that would be my simple answer to this. Which is not to say that if you can afford to, you shouldn't do this, but it's just not a prescription as such, because there are massive risks involved with not voting if you're a Muslim migrant worker in this country today.
Thank you, Darshana. And I think Shazin has a question, so you can take.
Yeah, thanks. So, Darshana, my question was with regards to the example that you gave, how an individual is presented in front of the foreigners tribunal in Assam. So, like you mentioned, we tend to present the voter list regularly, let's say from 66, then 76, then 86. So is this particular scenario, how are those particular individuals able to get such old voter list? Means, is it because of the local dynamics? People there knew that for long that such NRC is going to happen, or any specific things that the NGOs and the civil society people they did and enabled the people to get those particular documents?
Very glad you asked this question. I mean, it is specifically because of the way in which Foreigners Tribunal operate under Section 60. Section 60 requires you to show continuous residence in the state of West Bengal, and that has in the state of Assam, I'm sorry, and that has required some demonstration that you've been present in Assam at regular intervals. The Guwahati High Court has also directed that electoral rolls should be made available, and then subsequently in 2019, because of the NRC exercise, electoral rolls were made available, because a lot of people were using the older electoral rolls to claim as their linkage documents, that, oh, my father was in the 1955 voters list and this is my birth certificate and therefore I am my father's son, etc., etc. So it's a very specific thing that's evolved in Assam, because of
Okay.
both the FTs and because of the NRC process and because of the Guwahati High Court and because of the specific burden that Section 6A places. But the reason I'm very glad you asked this question is because I think it's something that should be done or that should be demanded for in other states as well. It is not difficult to, I mean, at least if it's been done in Assam, it should be done elsewhere as well. It should be made possible for people to access voters lists, historical voters lists in different parts of in other states of the country as well. And maybe that is something that we should consider asking for.
So, there's no,
I just want to
sorry,
say,
follow-up
sorry,
question.
just one addition to that, and because a lot of people who were caught in FT proceedings in Assam were from West Bengal, and a lot of people who had to apply for inclusion in the NRC in Assam had originally been born in West Bengal or had family there. We also saw the West Bengal government uploading historical voters list from, I think,
Oh,
1951 to 1971, and then the 1992 voters list as well. It's all there online on the, maybe I don't know if it's still there, but it was
okay.
certainly there till last month.
By
So
any chance, what is the judgment? Means, what was the case? Guwahati High Court, wherein
I
they
think it's the
direct.
state of Assam versus Muslim Mondol, but I will just cross check once. Bad memory for some of these things, and I'll maybe share the judgment with Mridula.
Sure, thanks.
Yeah.
Professor Hari has his hand raised.
Yes, good evening, everybody. Well, the binding precedent of larger bench where was already in place, but it was still not been followed to the core. Where is the justice done, even if sky falls? Why are we accepting it? What makes is Hitler went out of power only when he lost his World War? What do we see another war and then we lose this when this government can be overthrown or people have to come on street? What next? Because we don't see judiciary. Everybody who's moving in judiciary is not doing real justice to people. What should be the people stand now? Or in this case, how do we go ahead? Thanks.
Actually, that to add to that, and I think both Darshana and Sarfaraz can respond to it. What should people from other states learn from this whole exercise that has happened in Bihar and Bengal? And how can we, for example, in Karnataka, is going to start around 30th of June or so. So, what do we do as people, as lawyers? What do we do to mitigate the harmful impacts of such an exercise?
look, in economics, there is a theory, advantages of latecomers. So you have the advantage of latecomers, and the people in Bihar, uh, they had no advantage, or is, in fact, they were taken aback on the 24th June 2025, when there was a notice from Election Commission that they are going to revise the electoral list. So you can do many things. First of all, uh, you should be in contact with people like Darshana, who is in Bangalore, who can give you legal advices very quickly, how to protect your name, or how can you add uh, your name in the voter list. And every week you should visit Election Commission and give a petition, so that they could know, they should understand that there are people who have a tab on this process also. Secondly, all those migrant workers who are living in Bangalore, or they are voting in Bangalore, or living in any place in Karnataka, and they have voted in the last election, they are the most vulnerable people, because to change the voting pattern, the government is using this tactics very cleverly. Who are the people who are from Bihar and voted in Karnataka even once, they can delete their names from Bihar, so that the voter list, the voters of the India Alliance Party get reduced. It can be used like that, and they have used this method. And they can simultaneously delete those people's name from the Karnataka list also, because of because of the proof of their legality of citizenship is from Bihar. So you have to be very careful if you are trying to help those migrant workers. As Darshana has said, the most vulnerable community is the Muslim migrant workers. They have selectively deleted the names also. In the case of Bengal, we have found that. So you should always try to find such people who are most vulnerable. Thirdly, you have to be on the road also. All the civil society organization should be on the road all the time, so that Election Commission could not do anything they want to do. And you have to be in touch with the court also. If you get some people whose names have been, when you get the draft roll, in 1 month you will get the draft roll. If many people who are legally the voters and their names have been deleted from the draft roll, you should quickly go to the court, or should you go to the appellate authority. In Darshana will tell more about that. We can go to the High Court also, or only we can go only to the appellate authority. I don't know about that, because in the court you can have some respite, but in the appellate authority I don't think you will get any relief. We have seen in other cases also. So the civil society should stand together, united, and there is no other way we are seeing right now.
Sir, my follow-up question, since some people feel that my question is less understood. Sir, the process of SIR says in the year the election is to be conducted, there has to be no revision in the electoral roll. Now, everything is done, or election commission is doing against the set rules and precedent. They not only conducted SIR, they removed the name in last moment, as it was just shared by some of our learned friends. Just few days before the election date, that is model code of conduct, as you said, the names were the deleted list was updated. Now people didn't get the whatever there was the legal right, what was the fundamental right to cast their vote. Now this happened against, even if it is, of course, we may learn every time these election commission will come up with new tricks, new jargons, and new terminology, and eliminate uh, what they did in Maharashtra, what they did in Bihar, what they did in Bengal, their intention is only to get get into power. Now, what should be we realized what the court has also done, Supreme Court has done, is not justice. We all feel that injustice is there. Now, what should be done? Even if it is lost in one case, even if it is lost a case in Bihar, but just taking lightly, isn't it? Because if three judge larger bench is there, judgment prevails. The two judge bench can't this be challenged again with in front of that? This is against the three judge larger bench judgment.
This
Is
is
the injustice done against the people of Bihar? Can this be let go and say, okay, next election we'll see. Next election they will come up with something new. What they did in
yes,
Maharashtra, what
yes,
they did
yes.
in Bihar was another new thing. What they did in Bengal was another new thing. Every time they will come up with new ways, and we will say, okay, we learn the new ways. See, as things evolve, as things change, every time there will be new tricks, and new tricks till the time they are always in power. Being in power, they changed the panel who could select the chief justice, election commissioner of India. So they did everything what is and within their power. Now, what should be people of India doing rather than just watching? Oh, this is done. Okay, next we'll watch next. We'll watch next. Next means tomorrow. Tomorrow never comes. What should be your take on it, sir?
This is a purely political question. The people has to
No, sir,
decide.
this is not political, sir. This is the right of every individual.
Ah,
Maybe political,
yes,
not political, but the right of individual who has lost their rights to vote, or it's a very important right. Even chief
yes,
minister.
yes, yes, yes. The people of India have to decide what to do with this government or what to do with this system. When every kind of relief you can get from the court or any kind of government or anything, you are not getting any relief. Now, the last thing is people's power. So I'm unable to comment on this because has to be decided by the people. Now, like one of the internet sensation right now is Cockroach Janta Party. You have seen that. They are very, very angry with the system. So if this happens, we can see some change, but it is very difficult. The other day, they will find a masjid where they are going to dug out a mandir beneath the masjid, and then the janta will again sleep and say, oh, this government is the best government because they are finding the mandir beneath the masjid. So it is very difficult question to handle it in that sense, politically or non-politically. But we are here, perhaps Darshana will answer it more better, that is there any legal route to fight this menace?
Yeah, three judge bench and other previous set rule is not being followed. Now, my question to my judicial, my people from the field of judiciary, what should be done?
I mean, I guess that's the thing. No, they've not particularly overruled it, but they've distinguished this case from that law. If you mean the Lal Babu Hussain case, which is the three-judge bench case that you're talking about, I think, of litigators, Prashant ji and Shadan ji have left us, so we really don't have, the input from their end. But if Darshana could like maybe shed some light, and maybe then we can like end close this call as well. So yeah, Darshana, do you wanna?
Yeah, just very quickly, I don't have a comprehensive answer to this, but one thing is that we do have the Mustari Banu versus ECI judgment, which is the West Bengal batch of cases. We're still waiting for that, so we'll see what happens there. Because there are distinct questions which are raised in the West Bengal SIR as well, specifically the use of the logical discrepancy category after and the initial round of exclusions had been done. So we will see what happens there. Yes, of course, there are, you can seek a review of a judgment, you can seek a review, you can seek a curative. There are multiple options that happen even after the Supreme Court, a two judge bench has decided a particular issue. So all of those options remain. I do think just at the state level, I think it is really important to have a conversation and a rap and understand your BLO, right? because the BLO is the individual who is the interface between the voter and the ECI. The BLO is the one who's accepting documents and not accepting documents. There's a lot of anecdotal information that's coming out of West Bengal where BLOs have not taken all documents or have not submitted all documents. We don't know how true that is. But in order to avoid any such sort of slippages, in happening where you hand over something to the BLO or the BLO exercises their own discretion, I think it's very important to be in contact with your BLO and not as individuals, but in a more organized manner, just to because there are multiple pressure points on the BLO. The ECI is putting pressure. The state government is putting pressure, right? The BLO needs to be able to act independently and impartially and not be an agent of the ECI or the state government. And for that, I think that sort of, and the BLO is usually someone from your locality. So I think that relationship and that focus on like treating the BLO as an ally or an equal participant and not as an enemy is very, very important. The other thing that I'll just say is that, and I think we know all of this now, so I'm just repeating myself. Women have been excluded in very large numbers. Women are historically highly underdocumented in India. It is because women get married off at an earlier age and therefore do not have documents for education. Neither and the first kind of documents that they have, if especially if there's child marriage, then what happens is that the first time they're on the electoral roll is their name appears with their husband. So women have more documents with their husband than they have with their father, which is not the case for men, and that is often the reason why women are excluded. So it's very, very important that we are able to think creatively about how to make sure that the gaps in women's documentation is filled up. And the kinds of gaps that emerge is change in name after marriage, lack of any sort of linkage with their father, age discrepancies because their age has not been documented consistently from a very young age because of lack of schooling. These are 2-3 very obvious sort of things that come up. So yeah, we should really just think creatively about how do we make sure that women are not excluded from voting.
Thank you, Darshana. I think we will end our call because all of us have to leave. But thank you so much, Sarfaraz and Darshana, for joining this very significant conversation and sharing your knowledge with us. And of course, we thank also Prashant ji and Shadan ji for joining. Of course, they were with us for a very brief time, but they definitely have added very critical inputs into this discourse. So thank you all for joining and staying till the end as
Thanks.
well. This conversation happened under the aegis of the National Alliance for Justice, Accountability and Rights, and we are a lawyers collective that is interested in the question of constitutional rights and social justice and civil liberties. So that's briefly us at NAJAR. So I just wanted to like tag that in. I was supposed to do that in the beginning, but I'm doing it now. Sorry about that. Thank you all for joining. I think we can close this call now.
Thank you.
Zindabad.
Thank you.
And let's keep the fight going.
Thank you.